116710, State of Kansas v. Anthony Anderson.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing this morning on behalf of Anthony Anderson. I request 3 minutes for rebuttal, please.
3 minutes is granted.
Your Honor, this is a felony murder prosecution out of Bourbon County. The facts related to the tragic death of A.O. in this case and disputed stories. My client indicated that he was caring for this child. And at some point he had laid the child down on a couch and gone to clean a bathroom and heard a thunk, and the child had fallen off the couch. And he then, seeing the child in distress, took steps to get the child to a hospital. The child went to the hospital but had severe injuries, eventually resulting in the child's death. The state's theory is that Mr. Anderson shook or struck the child in some way, causing these injuries, and put on medical testimony to the effect that the injuries that occurred in this case couldn't have been, as Mr. Anderson described, from a child falling off a couch. And so the state prosecuted, and a jury convicted, somewhat reluctantly convicted my client of felony murder, and the district court has imposed a life sentence for my client. There are 3 issues in this case, Your Honor. My intent today is mostly to talk about the second issue with regard to prior bad acts evidence. The court may drive the discussion elsewhere, I know. In this case, the state sought and was allowed to admit evidence of prior acts, some things that happened approximately 3 months before the accident in this case, regarding testimony from a person that lived with Mr. Anderson and his girlfriend, regarding her saying that she saw Mr. Anderson be rough with the child, shake the child, yell at the child. And the state sought to put this evidence on, and the trial court admitted this evidence for the purpose of identity, relationship of the parties, and absence of mistake or accident. And it is our contention that that was an improper admission. I think the first 2 are easier. There was really no dispute about identity in this case. Mr. Anderson admitted he was there. There was no claim that somebody else came in and did this. So identity was not a material disputed fact. Relationship of the parties, I'm not even sure is an element of this case. I think it could be in a child abuse case, but I don't think it is under the state's theory in this case. But in any case, there's no dispute about the relationship of the parties in this case. That Mr. Anderson was the primary caregiver in this case was not in dispute.
Even if that's true, counsel, how do you get around the hurdle that this evidence came in without objection through other witnesses, specifically through Detective Eastwood's testimony?
There was I'm just trying to remember. I mean, I know that there was an objection to the evidence at the
when
pretrial hearing.
Is it right? There was a pretrial objection, and then there was at least arguably a continuing objection to, I think it was Tesla. Am I right? Tesla's testimony.
Yeah, I would argue there was a continuing objection to this testimony at any point.
Was that objection raised during trial at the time Detective Eastwood testified?
There had already been or at some point there was a continuing objection.
My understanding is that a continuing objection came after Detective Eastwood testified.
It certainly would have fulfilled the purpose of the objection, that if the district court had said, I agree with you, and at that point, I suppose you would have had that discussion about, well, do we need to go back and talk about other testimony at this point? So certainly the state hasn't claimed that the erroneous admission of Bodine's testimony was harmless because it had been admitted somewhere else. So, I mean, I hadn't really thought about it that much coming in here because the state hadn't made that kind of an argument. And certainly our argument is the objections that were made were sufficient and timely to the extent that if the district court had wanted to say, you're right, I reconsidered and I think this evidence should come out, at that point, maybe you're right that we would have had to say, and should it should we have to strike some other testimony too? It certainly could have happened. I think that the harder part of my argument was whether this was relevant for purposes of showing absence of mistake or accident, because certainly it is and was Mr. Anderson's theory in this case that the injuries in this case resulting to the tragic death were an accident. But the distinction here is it was not Mr. Anderson's claim that he accidentally did something to cause this. And we think that that's the important distinction here. That this court has noted that sort of this absence of intent or mistake or accident is sort of the flip side of intent. And this court has said just because a person pleads not guilty doesn't mean that intent, for example, is a material disputed fact.
I'm not sure I understand why laying a baby on the couch and with the assumption that the baby's not going to roll off, and then that happens, wouldn't be action by accident or mistake.
Because it's not hit. It's not like I'm doing something and like a gun. The example I would use is that I have a gun, I'm cleaning it or something like that. I'm doing something and I accidentally set it off. That's me doing something but accidentally. In this case, it's not the situation where my client was accused, under my client's theory, that he did something that caused the baby to accidentally fall. It's just an accident. And that we think that that's different than that when you talk about prior bad act evidence going to absence of an accident, it's absence of an accident on the part of an accused. And because of that, this prior bad act evidence was not material or relevant and obviously was very prejudicial. So we believe the evidence should have been excluded, and the state suggests that even if it was wrongfully admitted, it's harmless, and particularly given the jury's position, their expressions of doubt in this case, I don't think that this court can find that it would have not had any effect when the state puts this on. This is a textbook example of propensity evidence.
Why isn't this, I'm sorry.
No, you go ahead.
Okay, why isn't this, or distinguish this between other types of cases where there's, in a domestic violence kind of situation where this isn't just evidence of kind of a continuing course of conduct as opposed to a 6455 type of analysis? What's the difference here? Is it the time and place of the past behavior, or
it certainly is remote, and there's
is it remote? When did the alleged prior, as you frame it, a prior bad act?
Yeah, I'll
occur?
review it when I sit down. I would have said 3 months. It could have been, but I don't know.
Sooner, but why isn't this kind of a relationship of the parties continuing course of conduct, which would be admissible, which we've said is admissible in those kinds of situations?
Yeah. One, because we think it's remote, and I mean, there's not a, even if you believe her testimony, it's not like there's this continuing course. It's here's one thing that happened several months ago, and then this thing. There's not a showing of this like continuous, I saw him all the time be angry or abusive with this child. The second response, I guess, Your Honor, and I actually thought about this as I was reviewing for this, if that's the theory, and the state certainly did posit that theory somewhat in response to this motion, in regard to this motion, I think it does also change the nature of the first issue in this case with regard to unanimity. I thought that was sort of interesting, a quote from the state in this case with regard to this motion in limine, trying to encourage the district court to adopt the very position that you're questioning in this case, was that abuse isn't a single act.
Right.
And if that's true, I mean, maybe I'd have conflicting issues here, but if that's true, I think that that's reflective on the first issue in this case as well.
Counsel, I had a question. Your client testified it's an accident. What do we do with that?
With regard to the second issue?
The 455, yes.
That he didn't testify that it was his accident, though. He didn't say, I accidentally did this. He testified, and his theory was that it was an accident, not that he accidentally did something. And that's what, the idea of how it could be relevant for, with regard to the flip side of intent, still has to do with, did you do something with intent or did you do something accidentally? And so the argument in this case is that my client didn't testify that he accidentally dropped the child. It's just an accident happened.
And the best case you have for that parsing to support your position is what?
To some extent, I think Prine is the best case. When you talk about the nature of what absence of mistake or accident is, it's the flip side, it's the opposite sort of side of intent, which is also one of the things under 6455. All those things under 6455 have to go with, did the person do something with absence of intent, malice, motive, all these things about why did this person do this thing, as opposed to just why did something happen. So I think that would be one of the cases that I would cite for that proposition.
Thank you.
Explain the distinction. You indicated that absence of accident would be applicable if your client had dropped the child. Explain the distinction between dropping the child and putting the child in a position where they fall off.
Because the first is something that my client would have done.
Well, who put the child on the couch?
My client said that he put the child on the
But
couch.
for that act, the child would not have received any injuries under your client's theory. And I don't see the distinction of, oops, I've dropped, versus I'm going to set the child down in a place where they can fall off.
Sure.
Those
So-
are two accidents.
Yeah. I'm just sort of thinking about it out loud here, but I think about, like, I put my child in the car and we go out and somebody hits us. But for me putting the child in the car, he wouldn't have been involved in that accident.
But you have
But
an
I did-
efficient intervening cause there, and that's the person that hits you. Here, there's no efficient intervening cause. The but for was the act of putting the child in a dangerous position.
The intervening cause in this case is the child falling off the couch. Your Honor, I don't have any other presentation.
Any more questions? Thank you, counsel.
Thank you.
I want to jump right into the testimony of the defendant at trial. I'm sorry. May it please the court, Rachel Pickering, Assistant Solicitor General. There are 4 issues raised by the defendant in this case. He has addressed issue 2 regarding the 6455 evidence, and I'd like to address the questions that this court has just asked the defense. So at trial, he testifies, Mr. Anderson, and I'm going to go to page 115 of the transcript, volume 30. So after you burp him, then what happens? So this is the defense attorney asking the defendant. Answer, then I noticed he was shutting his eyes as indicating that he was tired, and so I proceeded to lay him on the couch so he could sleep. I mean, has he done that? Was the defense attorney defendant? Yeah, he's done that before. All right, so after that, does he go to sleep? From what I could see, yes. Okay, so that's on page 115. The defense is asking us to not call that an accident at all because he laid the child on the couch. On page 126, the defendant does say it's an accident. Question by defense attorney, on cross. Well, what really was it? Answer by Anderson, it's an accident, sir. Question, and that's what you want us to believe? Asked the prosecutor. That's what it was, whether you believe it or not. It's up to you. So clearly we have accident in play here. For us to start dicing up how we define accident is quite problematic, and I think would cause even more confusion. So this is definitely 6455, even if this court has issues.
I mean, it's clearly an exception to 64.
Clearly exception. Thank you, Justice. It's clearly an exception. and should come in. It's relevant, and it's more relevant than prejudicial.
Am I right,
And
counsel, just to clarify the record, is my understanding of the record correct, or of the transcript correct, that this evidence actually came in prior to I think it's Tesla Bodine's testimony?
I was looking at that officer testifies in volume 1. I don't have that, but I wanted to go back and clarify. We do not address that in our brief, but and there's case law already if it already comes in through one witness, and there's no objection.
But why is that? Why does that matter?
Because the bell has already been rung.
So that makes the testimony harmless.
Yes.
And why aren't you required to raise harmlessness? And if you don't, it's deemed waived or abandoned. You didn't raise harmlessness on even if this didn't fit within the exception to 6455. It was nevertheless harmless because the information had already been brought in by detective before that. You didn't make that argument. Did you?
We do make a harmless argument, but we do not address the fact that the detective had already made it. But we do make a harmless analysis.
So the issue is raised, just not that particular argument.
Correct, Your Honor. In our brief, we do not have that. The first issue was not, if there are any more questions for the second issue, I just want to jump to the first issue, which I found very interesting.
Let me just clarify. It's your position that this is 6455 evidence and that you met one of the exceptions. Is that your position?
Our position is we've met all three. Certainly we've met accident.
Well, how is identity even an issue here? There's no question about his identity and his being there, is there?
Well, we noted that there were no eyewitnesses to this event, and so the question of who did this, who could have caused the child injuries.
And is there any dispute about the relationship of the parties?
Well, the relationship of the parties is very interesting because it shows, I would argue that there is a dispute there. If we remember from Gunby, you had the defendant having a physical acts towards the victim. And this court looked at that under a relationship of the parties, the prior acts that the defendant had with the victim. And that was used in Gunby, although this court ruled on a different way. But this is evidence of an abusive relationship, aggressive towards the baby. Now, this court has asked about time frame. The baby is 6 months old when it dies. The defendant started dating the mother of the child when the baby is 3 months old. So within a time span of 90 days, we have an aggressive behavior by the defendant being shown. So it is evidence of abusive relationship tending to prove that the defendant has treated this child rough in the past.
Your point is that the relationship of the parties' angle for admission of the evidence is about the dynamics of the relationship, not its mere existence.
Absolutely. Thank you, Your Honor. That is the best way to answer it. It's the dynamic that it had. And this court looked at that with Gunby. And so that would be our argument as to why relationship of the parties. He attempted to portray himself as conscientious caregiver, and we're like, actually, no, let's take a look at how he's treated this child in the past, observed by somebody. If there's no further questions about issue two, I just wanted to point out for issue 1, this certainly is not a multiple acts question. For multiple acts, you have to have independent criminal acts that are at different times or different locations or different impulse. And here, it's just a question of shaking the baby or throwing the baby on a solid ground. This is an incident that occurred within one time frame. And it's not an incident like De La Torre where it's over a 3-month span of time. So that we would argue these are definitely, this is not an issue that would require unanimity instruction.
But you introduce evidence of other abuse, right? And so the harm here is when you introduce evidence of multiple acts that could form the basis for a conviction. If he could have been convicted before this last act of child abuse, then you've not set forth a scenario where we are confident the jury is unanimous about which act formed the elements of the crime.
Actually, you can be confident because the child, in the time it was with the defendant, stopped breathing. This is the 6455 evidence that came in was a friend of the mother's.
We're not talking about the death. That's a part of the felony murder. We're talking about, my understanding is the allegation or the claim is that the crime of child abuse, which is the underlying felony, had multiple acts put into evidence, and the jury wasn't told they had to be unanimous about which acts formed the basis for the child abuse.
It was but it is, for different acts, they have to be different times, different locations, or fresh impulse. And here,
Well,
we
I think
don't
we're
have
talking
it.
past each other. If you had evidence that yesterday there was abuse, and today there was abuse.
Yes.
But the child died today, and you said your claim is that the child died and the underlying felony was child abuse. How do we know that the jury didn't decide the child abuse conviction on yesterday's acts?
Because we don't have evidence of the defendant being abusive towards that child the day before.
I think Justice Johnson's referring to Tesla Bodine's testimony,
455
which
evidence.
was weeks before.
That's my point. That's weeks before. So you can be confident, and I apologize if I'm not getting clear on this. You can be confident that the jury convicted him for the crime that committed that day on April 26th, and not prior to, because the baby was healthy.
You can be confident that they determined the underlying felony of child abuse that caused the death occurred on that day. But wasn't he also convicted of separate count of child abuse?
Yes?
And that's what they're challenging here, is this, that's a standalone, and so the death doesn't relate to that charge.
Okay.
You understand what I'm saying?
Yes. If I
And-
could have one moment. To answer you, Justice Johnson, the reason why this court can be clear that the jury convicted him for child abuse is because of the jury instruction they received. On volume 2, page 78, the date of the offense is given. So, the defendant knowingly tortured or cruelly beat or shook the name of the baby. The baby was less than 18 years old. This act occurred on or about the 26th day of April 2015 in Bourbon County, Kansas.
So the prosecution has elected.
I'm sorry?
The prosecution has elected which act.
Yes, I mean that date.
The rule is elect or instruct, and you're saying we elected.
Yes,
Okay.
we have that. If there's no further questions,
I have a question quickly about the prosecutorial error
Okay.
claim. Is it the state's position that there is no error here?
That
That's
is
my
correct.
understanding, right?
Yes.
Just quickly, specifically drawing your attention to the defendant's claim that the prosecutor argued facts not in evidence, when the prosecutor kind of goes through the litany of Anderson gets frustrated, Anderson is angry, Anderson loses his temper. How is any of that? There wasn't any evidence of any of that, was there?
our argument, Justice Stiegel, is that is a reasonable inference to be drawn from the day of the defendant. That he was having trouble fixing his car, the rest of the family was at the lake, that a reasonable person could draw the inference that the defendant was upset.
But that's what I'm having trouble with. How do we know that? I mean, your family's at the lake and you get to work on your car, and I mean, that might be a great day for some people.
That is our position, Your Honor. That is.
It's just that it's a common sense inference.
Yes.
Well, let's say we disagree. Why is
And-
it harmless in this case where it's
It's harmless because we have 3 state witnesses coming in and discussing that this child had, discussing the overwhelming medical evidence to show that this child was abused. You have testimony from the treating doctor, the pediatric radiologist, showing that this is definitely from child abuse, noticing also a fracture of the left ankle. You have the pathologist doing, from the autopsy, realizing that this would be from a child who suffered brain trauma.
so you would hang your hat on the overwhelming nature of the medical testimony,
Yes.
essentially.
That level of injury can only be achieved by an angry person, in essence?
No, Your Honor.
Because, I mean, babies are fragile, right? They're
Yes.
more fragile than an adult.
Right.
It takes a lot less force to hurt a
Right.
baby.
But we're not, the overwhelming evidence that a crime was committed here in terms of abuse of a child.
But it wasn't uncontested.
We don't have to prove the nature of the person's mental state.
Right.
That's
No,
not a burden.
I agree with that, and that's part of the problem here. It's why does a prosecutor have to talk about it if that's not something you need to prove? And isn't it just kind of casting aspersions on the defendant? That's why there's an allegation of prosecutorial error to begin with. Not only on that remark, but on the other remarks as well. And right now I can't call them word for word to mind, but you know what I'm talking about.
Yes.
They're really all of a piece in terms of kind of just a display of attitude about the defense, which we sometimes say goes over the line. So the original question was harmlessness, and I think what you said is the evidence was overwhelming.
Yes.
Okay.
Yes. We still argue, we start with the first argument that it was a reasonable inference. If there's no further questions?
Any more questions? Thank you, counsel.
Thank you.
Reserve 3 minutes for rebuttal.
The only point, I guess, would just be to respond to the last point on whether it would be harmless if you find it. And again, I would really point to the question then would be, but for the error, are you confident that the jury would have come back? And the state suggests there's overwhelming, I would suggest there's conflicting evidence at best. And that's fine. I mean, we have trials all the time where there's conflicting evidence. But we have a little bit more evidence in this case because we know the jury came back and specifically asked the district judge, do we have to convict him of felony murder? And the judge said, yeah, that's your choice. It's that or nothing. And so we can even glean a little bit from that the jury here was really struggling with what to do in this case. And I don't know in those kind of circumstances how, if this court finds that there was any error really, that it could be harmless.
Can you tell me what the multiple acts are here?
The multiple acts are the state put on evidence, their own medical evidence, that that the child was either shaken or thrown against something.
I understand that, but those are alternative scenarios. That why is it could have been this or it could have been that. That's not multiple acts.
Our argument is that they are multiple acts. They're factually distinct. My colleague has noted one of the factors, and for example in De La Torre,
So your argument is since they provided evidence that the specific act could have been one of two things, that creates a multiple act scenario, even though it's unquestionably one act by one person that's known
At one time.
at one time. That's your argument?
That caused one result.
the argument is that shaking a baby or throwing a baby hard against something are factually distinct acts.
They're certainly factually distinct, counsel, but was the testimony that both occurred? The
The
testimony was that one or the other occurred, wasn't it?
The testimony was one or the other or both occur. I mean, I don't think the testimony was
Okay.
it was one or the other.
But one or the other wouldn't get you to multiple acts. That's what my colleague's point is.
Right.
Both gets you there.
You can only have one conviction. He either did this and he's guilty, or he did this and he's guilty. And I think our case law says you have to have distinct acts that would independently form the basis for a conviction without more. And so there's no way he could have been convicted of 2 counts under this scenario, is there?
Oh, if the state had, and if the evidence was, I think, that he had struck the child and shaken the child.
Well, no, but that isn't evidence. We have, you just said the evidence was this or that, didn't you?
Yes.
Okay, and it was charged as 1 count, and if they had charged 2 counts and said either this or that, it wouldn't have supported 2 convictions, would it?
Oh, I think the state would have absolutely argued it would support 2 convictions.
Your argument up here would have been those were alternative counts, they were not multiple counts. Because there was only 1 act, it was either this or that.
And I mean, I think the question is, would this court have said those are factually distinct things? That's the state put on evidence of factually distinct things. A jury needed to be unanimous on which of those it was, or both.
Any further questions? Thank you, counsel.
Thank you, Your Honor.
We thank you both for your arguments this morning. Court will take this matter under advisement.